Hi, students, and welcome back. This lecture is for our week 4, chapter 4 presentation of our constitutional law class. So, I this chapter is a little bit tricky. It's one of the more tricky topics within constitutional law. So, I want to simplify it and keep things simple. If you have any more questions, however, you may find more resources available online that I have posted on our website for you to be able to explore and learn more in detail about some of the topics we're going to talk about today in class. So let me share screen. And let's get to it. Chapter 4 deals with civil rights and civil liberties, the basic concepts of civil rights and civil liberties. And really, what we're going to explore in this chapter are the 13th and 14th Amendments. So, the reason why we have these amendments, well, let's talk a little bit about the background that led to the creation of these amendments, right? So when the Constitution was created, the framers, the authors of the Constitution, wanted to restrict the federal government from becoming too powerful. Even though they wanted to give it more power than what the government had, what the national government had under the Articles of Confederation, there was still a lot of fear that a government that would become too powerful would be similar to the king and that an authoritarianship or the monarchy that American colonials felt while they were still part of the British Empire. So one of the purposes of the Constitution was, yes, to strengthen the national government, but by the same token, to prevent the national government from becoming too powerful, that it would infringe on people's rights. So, as the Constitution becomes the document that creates the national government, the federal government of the United States, issues begin to arise. And the issues really begin to arise because supporters of states thought that states should be more powerful than the federal government. And there were other people who interpreted the Constitution as meaning that the Constitution and the federal government had final say on certain matters over the states. And this became a very controversial issue regarding primarily the issue of slavery and who had the final say over slavery, whether the national government did or whether individual states did. But it also presented itself in other problems involving who had the final say to collect a tax, for example, who had the final say to start a bank. Could a state government create a bank that could charge interest to federal banks? Could a federal bank be created that had more powerful than state banks? And these were different issues that presented themselves throughout the early 18 and mid 1800s. Eventually, these issues come to a head with the election of President Lincoln, right? So Lincoln gets elected in 1860, and while Lincoln promised that he wouldn't outright abolish slavery on his own, the southern states didn't believe him and they broke away from the country, from the Union, and the Civil War begins. So Lincoln is tasked with trying to constitute, to bring back, to make whole the country again and bring back the southern states, and a civil war is fought. So this becomes a major, a major issue because the southern states feared that if they remained a part of the Union, then slavery would eventually be abolished and that Lincoln would lead the charge. Now, before the Civil War took place, one of the most famous, and I should really say infamous cases that the United States Supreme Court ever decided was Dred Scott versus Sandford. Dred Scott versus Sandford was a case that essentially decided that even if you were a free African American, you could not be considered a citizen of the United States and that you did not have any rights that a white person had an obligation to respect. So this became very upsetting for Northerners, right? Um, because and obviously black people, because basically they were it literally said that black people were not considered citizens of the United States. So we have the Civil War. Americans fight Americans. It becomes a very bloody and very ugly war. The wounds of the Civil War are still in many ways felt in this country to this day. Uh, and towards the end of the Civil War, uh, President Lincoln abolishes slavery everywhere in the United States and in the southern states through the Emancipation Proclamation. So his argument at that time was that this was necessary for the war effort for the United States to win the war. So he said that he had the power in the Constitution as the president, as the executive who was tasked with being the commander in chief under the Constitution, to eliminate slavery for the purposes of mobilizing and strengthening the Union effort to bring back the southern states to the United States. So with that rationale, with that argument, with that very clever argument, President Lincoln eliminates slavery. Now, the North wins the Civil War, and one of the conditions that the North places on the southern states is that they have to ratify or approve the 13th, 14th, and 15th Amendments. The 13th Amendment abolishes slavery, which means that now in the southern states, slavery is no longer allowed. Slavery is no longer allowed anywhere in the United States because the 13th Amendment to the United States Constitution eliminates slavery. And even though slavery was eliminated, southern states in particular discriminated against black people. They still purposely tried to deny black people their rights. So the 14th Amendment gets passed, and under the 14th Amendment, African Americans, black people, they now are given the right to citizenship, because nobody can be denied the right to citizenship if they are born in the United States or if they are naturalized in the United States. So this eliminates the decision of Dred Scott versus Sandford. Now, the 14th Amendment also does something else. The 14th Amendment also tells states that they cannot deny their citizens what is known as the due process of law or the equal protection of the law. This is very difficult to explain. This becomes very tricky. You can spend weeks learning about this in law school, so I really don't want to get too caught up into this because I think it can become very difficult. However, like I said at the beginning of the lecture, I have provided materials on our website for you guys to go ahead and be able to explore the due process of law issue and the equal protection of the law issue more if you have any questions on it. Essentially, however, what the 14th Amendment says, again, like I said, is that anybody that's born or naturalized in the United States has the citizenship. They're basically U.S. citizens, and their citizenship cannot be in question. So this eliminates the Dred Scott decision, like I told you, and you cannot have your rights as a citizen restricted. Or your due process restricted by any state. This is very important because the Fifth Amendment to the Constitution of the United States says that the federal government cannot deprive you of your due process rights. And I'm going to explain in a little bit what due process means. But the Fifth Amendment applied only to the federal government. And if you remember when we discussed the Bill of Rights, the Bill of Rights initially were only written to protect individual Americans from the federal government depriving them of their rights. But the Bill of Rights were not originally intended to restrict states from being able to violate your rights. The idea was Americans initially were not afraid of their own states restricting their rights. They were afraid of the federal government restricting their rights. And while This was true for white Americans who had property. This was not true for African Americans, for black people. So once slavery is abolished in the 13th Amendment, black people had no recourse, they had no protection against state governments who tried to restrict their fundamental rights, their most important rights, even those that were protected under the Bill of Rights from the federal government taking them away. The state government still had the ability to take away those rights until the 14th Amendment is passed. And the 14th Amendment does something that's very interesting. The 14th Amendment incorporates the rights that are found, the most crucial rights that are found in the Bill of Rights, and says that states, individual states, must also honor those rights. So let's talk a little bit about what incorporation means. Incorporation means that states have the obligation of adopting the most important rights that are found in the Bill of Rights to their own laws, and that individual states may not eliminate an individual's fundamental or important rights because they have been adopted or incorporated to the states because of the passage of the 14th Amendment. Okay? So, in simple terms, the 14th Amendment forces the Bill of Rights, or the most important aspects of the Bill of Rights, to the individual states. So that no longer may a state pass a law, for example, that unfairly restricts a person's freedom of speech, because that is an important right that is protected under the First Amendment. And because this is a very important right, it has been incorporated under the 14th Amendment. It has been included because of the 14th Amendment to mean that individual states may not remove that right from an individual person. That's what incorporation means. Now, the 14th Amendment makes sure that individual states respect a person's due process rights. And due process essentially are the rules and procedures that are in place to make sure that the government doesn't try to violate your rights to have fair results, to have fair outcomes. The government cannot treat you, but the state government, according to the 14th Amendment, does not have the right to restrict your ability to seek fair outcomes. The government may not arbitrarily or randomly treat you unfairly in their actions or in their laws because of this concept of due process. Now, the federal government already couldn't violate your due process because of the Fifth Amendment. But now state governments may also not violate your due process rights because of the 14th Amendment. And we can divide due process rights into two categories. We can divide the due process rights into what are known as procedural due process, and we can divide due process into what are known as substantive due process. What is procedural due process and how is it different from substantive due process? Procedural due process involves how laws are applied in a particular situation. So you get arrested and you have the right, you get arrested and you have the right to have a lawyer represent you. You have the right to an attorney. That is found in one of our amendments in the Constitution of the United States. You have the right to have a lawyer and to have your lawyer present with you while you are being questioned if you want. That is known as procedural due process, meaning that throughout the process of your arrest and of your potential trial, there are certain rights that you have in that process, in that throughout those procedures, the government may not restrict. One of them is the right to an attorney. That is an example of a procedural due process. All right. You have the right to a phone call. That's another example of a procedural due process. That's part of the procedure of how laws involving an arrest must be applied. Substantive due process, on the other hand, requires that whatever laws are passed are themselves fair, regardless of how we enforce them. So let me give you an example. The government may not criminally punish a person for choosing to express their political opinion. That is an example of a substantive due process issue, because you have the right to freedom of speech and to be able to express yourself how you see fit. And so if the government tries to restrict your ability to do that, the state government, they have violated your substantive due process, which has been incorporated. It's a right that we find in the First Amendment that has been incorporated through the 14th Amendment to individual state governments. Okay? Just remember that substantive due process deals with the issue that laws themselves must be fair, whereas procedural due process refers to how laws are actually applied or enforced. Okay? So maybe there's a law against murder that is fair, so where there's no substantive due process issue, but the process of your trial, as we are figuring out what should happen to you if you have been accused of having committed murder, you have the right to having a fair trial, a fair process with a jury and a lawyer, and those rights cannot be removed from you. Those are called procedural due process rights. Whereas substantive due process rights require that the laws themselves that are passed that can actually be used against you in a criminal trial, those laws themselves must be fair and must not violate other provisions of the U.S. Constitution. And they are applied to the state government through the 14th Amendment, because the 14th Amendment incorporates your due process rights that are found in the Fifth Amendment and in other parts of the Constitution to the individual states. So that's all I want to talk about with the incorporation doctrine, with procedural due process, with substantive due process. Let's talk about an example of a substantive due process issue. Okay. In the state of Louisiana, a person was found could be potentially found guilty in 1968, and found guilty of 2 years in jail. And the state did not want to give that person who could be potentially found guilty and receive a punishment of 2 years jail time a jury trial. This is an example of a procedural due process issue, because under the Sixth Amendment, in a criminal trial, every American has the right to a jury trial, and this has been incorporated to the states. This right has been incorporated to the states, meaning this right has been copy-pasted to the states because of the 14th Amendment through what we have called the incorporation doctrine. Therefore, if a state tries to eliminate your right to a jury trial in a situation where you could potentially go to jail for 2 years, they have violated your due process rights, your procedural due process rights to a jury trial, which are found in the Sixth Amendment and incorporated to the state through the 14th Amendment. Okay? And that's what this case, Duncan versus Louisiana, was about. Very briefly, I mentioned Lochner versus New York. Lochner versus New York involved a state law that prohibited a baker being able to work more than 10 hours a day or 60 hours a week. And the reason that New York passed that law was because they wanted to protect the welfare of bakers. They didn't want bakers to overwork themselves. And the question is, does that violate a fundamental substantive due process right? Does the law itself unfairly restrict in subject matter a baker's right to work however many hours they want and create it, based off of a contract so that they themselves can earn more income? And the US Supreme Court found that yes, this law violated a baker's right to enter into a contract, and that the idea of entering into a contract without having the government unfairly restrict a person's right to getting into a contract was a violation of substantive due process found in the 14th Amendment, and that a state could not restrict a person's right to getting into a contract because the law itself for everybody was unfair. And that's Lochner. Okay. Now, some of the rights in the Bill of Rights are enumerated. What this means is that they're actually spelled out and we can specifically talk about them, right? So like you have the right to freedom of speech. Well, that's actually flat out stated in the First Amendment. We call these rights enumerated if they are flat out written out. Unenumerated rights, on the other hand, are not flatly stated. They're not expressly stated. You won't find those words written out word for word in the Bill of Rights, but they are implied. We've deduced them from the different amendments as being present in them, even though we don't actually see their words spelled out. An example of an unenumerated right is the right to privacy. If you were to look to the Bill of Rights, you will not find the phrase right to privacy anywhere in those rights. However, so it's not an enumerated right because it's not spelled out, it's not explicitly stated. But it is an unenumerated right. I'm sorry. It is an unenumerated right because it is implied. It is a right that is necessary for other rights in the Bill of Rights to exist. Okay? I don't want to talk about strict scrutiny. I don't want to talk about the rational basis test. You might see those in these slides. I'm gonna skip over them. I don't want to talk about Nebbia versus New York. I don't want to talk about Grissom v. Connecticut. I'm going to continue skipping over these. I don't want to continue talking about racial discrimination or any of these slides. I don't want to talk about affirmative action. I do want to talk about discrimination, the difference between discrimination. No, I'm sorry. I do want to talk about, where is it? Here we go. A right and a privilege. And this is the last thing I want to mention, and we're done for today's lecture. A right is a legally protected claim, meaning that the government may not take away your right. A privilege, on the other hand, is a claim that is not legally protected, meaning that the government may take away a privilege. Okay? So I wanted you guys to keep that in mind and understand those differences. And that is it for this chapter's lecture. I'll see you guys next week. Take care, guys. Bye.